Be ready. 5 seconds to go. At the first instance, the learned counsel for the appellants strongly argued that there was perversity and illegality involved in the decision rendered by the tribunal, which was affirmed by the High Court. It was also argued on behalf of the appellants that a fair and reasonable opportunity of hearing was afforded to the respondent, and the charge sheet did not suffer any discrepancy as it sufficiently enabled the respondent to defend his case. Furthermore, it was contended that the charges framed were not vague and were serious cases of misconduct. It was further argued that the tribunal and the High Court had appreciated the evidence wrongly, and it would not be in the interest of appellant company to keep a workman who has developed the habit of abusing superiors with filthy language and disobeying their orders. Accordingly, the learned counsel for the appellants prayed for setting aside the judgment of the High Court as well as of the Industrial Tribunal and restoration of the order of dismissal passed against the respondent. The learned counsel for the respondent contended that the respondent was denied a fair hearing and was dismissed in violations of the principles of natural justice. It was argued on behalf of the respondent that the charge sheet did not contain the specific abusive language, and thus it was difficult for him to defend his case. He further argued that the respondent was not furnished with the list of witnesses and copy of the documents to be treated as evidences and materials on which the management was to rely, and he was also denied a chance of being represented by a lawyer or a representative who is equipped with legal background during the inquiry proceedings. The learned counsel for the respondent also contended that the appellants had not presented before the court any documentary evidence to prove that he had on earlier occasion misconducted himself and was thus in a habit of disobeying his superiors. The learned counsel also strongly argued that the work assigned to the respondent was not part of his duty, as he was appointed to carry things from one place to another outside the shop. Finally, the learned counsel for the respondent argued that since the concurrent findings of fact arrived at on the question formulated herein above, it is not open to this court to exercise its discretionary power under Article 136 of the Constitution to interfere with the impugned order on such concurrent findings of fact. Let us first delve into the most crucial question raised in this appeal, that is whether there was violation of principle of natural justice. The principle of natural justice is attracted whenever a person suffers a civil consequence or a prejudice is caused to him by an administrative action. In other words, principle of natural justice is attracted where there is some right which is likely to be affected by any act of the administration, including a legitimate expectation. The second appeal has been dismissed by the Board of Revenue by the impugned order dated 11th May 2011, holding that no substantial question of law was involved, and accordingly, the orders dated 31/3/2011 and the order dated 27/12/2008 were upheld.